in the hearing. I'm going to turn the floor over to you, Ms. Lane, in a moment. But I want to begin with just an observation. We have had a number of cases where attorneys have relied on the seductive appeal of artificial intelligence to do their work for them. And I just want to start off by saying that the use of artificial intelligence is absolutely not prohibited or inappropriate. The use of it without verifying its contents is an act of negligence on the part of an attorney. But, and this is what I want to emphasize for you today, misleading the court or being less than completely candid with the court about the circumstances under which false citations came about would be a huge mistake. It would trigger a non-discretionary obligation on the part of the court to make a report to the ERDC if we concluded that you were attempting to mislead about the circumstances under which false citations got into your work. So I'm going to turn the floor over to you and just ask you to please pause, think about what you're going to say, and choose the path that avoids that second mistake.
Thank you, Your Honor. First, I do understand the seriousness of this court's order, and I want to begin to, stating clearly as you made the point of it. First, I have to, and I am taking the full responsibility for the brief filed under my name. However, there was no intent to mislead this court. That said, as I have indicated, my full intentions from the beginning. I do have medical condition. I do have ADA conditions, and I respectfully requested extension so I could fully myself alone take charge and do the work. I am very anal person. I'm perfectionist, and it never gets done with being perfect. But when I was granted, and I want to also note, when I took this case, I did not know what I'm getting into. I didn't know there were 3 cases combined. I didn't know my appeal is going to be over 15,000 pages. I came in less than a year before the appeal, and the other counsels were on the case at least 3 years from the inception of the case. My part in it, when I saw what I saw and clients constantly telling me the documents are still missing, everything is missing, I was put in a crunch. It was a holiday season time too. I wasn't well on top of it, but this 2 weeks I knew was never going to be enough. So I asked, and I attached to my third extension. But the first one, when they granted me, or the second one, and I apologize, I'm very nervous. I take it very serious. I was granted like 5 days with a weekend included. And then I was begging the court for more time. And I normally don't want to mention my ADA, my medical, that's private things. But I threw it out there to show I cannot in 2 weeks accomplish this. So I was forced to delegate portions of it, which I have to take full responsibility for, because as this court is aware, I didn't even finish to file it by 11:59. That shows I was exhausted. I was trying to do the right things, but I did delegate it because I had no choice. And my delegations, they were legal assistants, but we didn't have time to cross-reference, to finish it, as I would have liked to do, putting myself right now in the shameful position here. I am ashamed. I am embarrassed. But I begged the court for time. And then I immediately noticed that because it wasn't finished, I received also from the persons that I delegated apologizing for letting me down. But no matter who these players were, I signed off, and it's only on me. I am not saying this to make an excuse, Justice Doherty. I am ashamed. This never happened, and it will never happen. But as I explained, the November 5 order giving me 14 days, 15,000 documents, and they're all over the place. I had to read them, understand them, to find them and put them in the places while I was involved with the substantive part, trying to still piece together what goes where. I'm taking full responsibility no matter what. I signed off on it. Do I know 110% the delegation was not proper? Do I use IA or artificial intelligence? I am not technically inclined person, but I do use it because even though I'm not fully Turkish person, but I speak Turkish and my clients are from Turkey. And as I stated in my response, I have strong connections to Turkey. Not anymore. Everybody's wiped out there now. I use it for translations. You know, what do the clients say in the email? What documents they send? Because I didn't grow up in Turkey. I grew up in Germany. My language school, but I am not there yet. And I am aware you can use artificial intelligence as long as you cross-reference, you double check everything that you do. And in this, it was unavoidable because I didn't have time. I didn't have time to go through it. So on December 15, I humbled down and I asked to amend this complaint to show you that I know that I need to fix it. I need to bring it to the court's attention, not to deceive the court, not to make misrepresentation. In my second paragraph, I stated it. I know there are errors in citations, but I wasn't granted that time. And the opposing side constantly objected to everything. And they said I could fix it in the reply brief. And reply brief situation is also known. I had no chance to correct anything in my reply brief either. I am a human being. I'm 62 years old. I'm not a super person. And I know how sincere and how important this profession is. I would never want to embarrass myself first. I've been suffering with this since November 19. But it happened, and I took responsibility. And again, I asked to allow me to make the corrections. But I humanly could not do it. I could not do this in 2 weeks. So it's not intentional. It's not misrepresentation. I delegated parts, and the people I delegated to also had no time, illness. It just didn't work in 2 weeks. I couldn't do it. I apologize. I apologize, and I know me. This will never, ever, ever happen again. This humiliation is enough to take me to my grave, because in my 20-some years, first time I stand alone, solo practitioner, no support staff,
no financial support. I don't have the big firm like the opposing counsels, and I didn't understand why they constantly object to my extension. And they say, why did she come up with her ADA just now? Who talks about it? Who likes to mention it? I'm a competent person. I have my situation, and Lord knows, since COVID, everything started going bad. I had to dissolve my firm, let go of everybody. And then the earthquake in Antioch, Turkey took all my sisters, my family, my uncles. I was still in depression, and I am taking medication, and I'm not making that as an excuse. I'm just saying it. I am human being. I just couldn't do it. I couldn't do it. And like I said, I do understand where you're coming from, because if I were in your shoes, if I were the justices sitting there, I would ask Miss Lane, the rule 109, you signed it, you filed it, we're done with you. If you like to look at me as a number, you're done with me. But the subparagraphs say, did you do it intentionally? Did you do it fraudulently? Did you do it to misrepresent the court? When you go to the second step, I did not. The file stamped 1159 should tell you, and the several extension requests should tell you. Justices, I did not know what I got myself into when I took this case. I would have never taken this case if I knew I was going to be put in a corner and be put with the situation that I'm forced to delegate because there was so much material. And the worst thing is I had my motion to vacate there, and that's what I provided to them. Here is what I have. Work with this, what I have, while I'm doing this other thing. My 1401 motion was proper. Cases were proper. I didn't know that the delegation would jump and not use all of those cases, but then it did make sense to me because we have so many reporters, everybody working remotely. And I give them the name because when my computer crashed, I had to go through my notes. I remembered certain names and I gave them, this is the case, don't forget this case. And then later on, I noticed the names that I given them as part of that name, but it didn't have all of the names on it. And I knew immediately, I was in that situation. I knew I signed, I knew I filed, but if you want documentations, I have the documentations. My primary care physician, she listened to me. Nobody could understand why I could be in this situation with no time. And I don't want to press ADA request, but right now, justices, I am begging you to allow me to amend the complaint, even though it's probably still not 100%, but to show you, even after that day, I said, and I read, and like I said, there is documents still missing. They say I got in a situation I just didn't know. I could have withdrawn from the case right before filing. I would have been the worst person in the world if I'd done it, doing that to the clients in the last minute, like the other attorneys. I could have not filed it because I didn't complete it. That would have been another worst thing. The clients would have killed me probably. And then I thought, the worst scenario is we do the correction. I know the greatness and forgiveness in the hearts of the justices for inadvertent issues. I was hoping that I could amend it, explain it. I couldn't reach out to any individual, like when you're drowning in the water, you just start, holding on to anything that comes your way, branches, snakes, crocodiles. You hold on to anything to stay over water. I am not Superwoman. I am not an evil person either. I've been given this job to do the best I could. That's why I filed the 1401. But that said, I understand that the responsibility for the filed brief remains still mine. And I do not shift that responsibility. And I raise this issue only to demonstrate that there was no intent to mislead, and that I made good efforts to correct the issue before this court. And right now, that Mr. Paul Mangieri and George Becker and whoever these attorneys are here, it is more humiliating to have them here. I don't know why they are here. When I begged them for agreeing to extension with me, they would never agree with me. We attorneys are professionals. We're supposed to be civil and responsible. In professional courtesy, I begged them for extra time. I'm new to this case.
I'm going to follow up with some questions, but I want to summarize what I've heard. You have basically explained that the briefing in this case was a bigger task than you thought it would be, that it hit you at a difficult time, and that you delegated, without specification of what you mean by that, the preparation of some of the briefing. But I want to follow up on your response to this order. As I understand it, your contention is that you intended to cite the cases in re Estate of Burke from a different case, a federal case named Dragon versus Miller, and another state case called Waller versus Davis, that you intended to cite those, and that somehow the names of different cases called Burke, Miller, and Davis got into your briefing. That's difficult to understand, how a citation would track from one name you gave it to then making up down to a paragraph cite the citations that ended up in your brief. How is it that happened?
As I stated before, I was working with my notes, and I did give what I could remember. And I told them, don't forget this case. And I just knew some portions of that name. And they didn't pull the right one in there because I wanted it in there.
Okay, but if you're telling us that the right cases are this Burke, the Dragon case, and Waller, they don't even support the proposition they're cited for. So that gives us the concern that you're misleading us now by telling us that you intended to cite. For instance, why would you be citing a federal case about federal jurisdiction on a state probate law matter? Why would that have been your intent?
I didn't know it was federal case or not when I was citing it. Anyways, I just read so many cases through it, and that's where I'm saying I'm taking the responsibility for.
Oh, no, these are the cases you've given us since this order that you're telling us that you intended to cite, and they still don't support the propositions that the fictitious cases were cited for. It's as though you're backfilling in and telling us, oh no, I intended to cite these cases because the names are similar, but they still don't have anything to do with the case. It's hard to accept that you're being candid with us about that.
Your Honor, I am more than candid. Like I said, I did delegate portions of it, and I did work on the amendment. And like I said, I don't know everything. The cases that I cited in there, we were pulling from, Lexis, we were pulling, I don't know, but that's what was given to me. And this is what I supposed at the last end double check. If I had double checked every single case, even in the amended version, if that had been granted, if that time had been granted, I would have one by one gone through it. I didn't have time to go through them. I didn't have time to think about it.
Right. What I'm asking you about is after you did have time to think about it, and after you got our court order asking you to explain, you've given us a very difficult to believe explanation that somehow you had notes of other real cases that you intended to cite, and yet those cases don't support anything close to the propositions that you used the fictitious sites to support.
When I put that name in to my Lexis, and sometimes, it shows to you the same, like I was pulling Wilkerson the other day, and it says Wilkerson with Martini, and there's certain, drop boxes. You just pick one of them, and I can't explain that because I pulled it. I pulled that case. As I stated, I just didn't have enough time to cross-reference to check. You're right. Why am I citing that? Honestly, at that time, under the mental condition, I couldn't think clear. I didn't think clear. But all I can say is, if this court wants to give me another 3 weeks to redo it, and let me show you what I can do, without, and always something is going to happen when you're solo practitioner. When I pulled those cases
Elaine, I
said,
have a question. I have a question, if I may. And I think Justice Doherty alluded to it. When you say you delegated to who? And I don't mean by name, I mean by status. Did you delegate to other lawyers? Yes or no?
yes.
Okay. So you delegated to other lawyers to do some of your research.
Yes.
Okay. Did you at any time in this case, not for translation, did you use artificial intelligence to create any brief or any motion?
I myself personally, no. As I explained, I was cataloging the files, reading the files, but do I know if other delegated individuals did it? 100%, I cannot say either way, but I think yes.
Did you ask them?
All I thought is, no matter who used it, if they used it, I have apology text messages. I am to be blamed, so I cannot, whatever it is, I have to swallow this one. This is on me because if I had known, what I'm getting into, I would have never been in this case. Hindsight is 2020, but I told the client, you need a big firm to do that. I am supposed to be semi-retired, coming in, doing just an appeal, which is not supposed to be this way. I was forced to delegate it just to get that brief done, and I don't put anybody under the bus. I am not gonna name names because that would make me look bad. I'm not pointing finger because I signed. And those cases, even the amended one, did we continue thereafter, after November 19th? Did we, the same individuals, try to make amends and correct it together? Yes. Did I do the final review of it just cursively because I am solo practitioner? I had other cases. So I was hoping, after knowing the mistakes that we did from round one, that the round two would have not had this federal case like cited in there. But
But that's the
again,
one that's the one you've told us in response to our order. You've
Yeah.
told us that's what you intended to cite.
but I would have used it, Your Honor. You know why? Because I'm still not super great with knowing, for example, I'm using lately I am using just Seventh Circuit or only our appellate courts. But when I'm writing other things and when the good cases come up for persuasion and stuff, and that I am using it wrong, yes, I probably am using it wrong. But using it wrong is, I can deal with that I used the wrong case. But I cannot deal with it that I, intentionally try to mislead the court. Did I make mistakes? Of course, I made the mistakes, but as I stated there, it should attributable to, the totality of the circumstances. And I know, you're going to say, oh, she's looking for excuse, or this is her excuse. It's not excuse. I'm trying to explain. I, by myself alone, could not have done all of it in such a short time. If the time had been given, like I just filed a petition for rehearing, it was, again, very difficult to do it within the 3 weeks. I didn't want to, ask for extension and anything. I killed myself day and night trying to read those cases, wrong cases, read these cases, is wrong cases, go to the next cases, from this case, get this. I am blinded just reading. And I don't think this is one attorney job. That's why we had our offices. That's why we had other attorneys, everybody doing certain section. But do I cite the wrong federal case in a state case that is not relevant? I might have read it, that it would support it, because there were more than one Burke in there. But I am rushing. I'm constantly, I feel like trying to catch my tail. I'm rushing. Before I finish this thought, another thought comes in, and before I do, I am playing catch up.
You weren't rushing in response to our order, were you? You were trying to defend your conduct?
No, when I responded, Your Honor, I just used the material that I had in December. And
Stop there a minute. You knew that there was trouble afoot when we issued the rule to show cause.
Yeah.
You had the opportunity to try to be careful and not rush through your response. Do you think you spent a sufficient amount of time in your response to the rule to show cause?
I felt, if I go back to the December 15, what I had, because that was the amendment that I was trying to do, I couldn't come up with new cases to respond to this show cause. I wanted to stick what it was in the past. These are the cases that in the amended that I used in time to show you my sincerity, trying to put the proper cases in. If I had, after receiving this order, went and found that or the different brand new, then I would have been still in the same situation because I didn't want to come up with new cases than what I had in December.
Counsel,
And-
let me ask a question as well. We understand that your position is that you had all of these obstacles in preparing the original material, but you since have had time in preparing a response, and Justice Doherty did a good job of outlining some of our concerns with that. But with regard to something Justice Connect asked, and that is these delegated works, you knew again that trouble was afoot today with this hearing potentially, and you've not asked the people you delegated the work to if in fact they used AI. And I'm curious about that, why you wouldn't do that just to prepare for this hearing. Wouldn't that seem to be a prudent step just to prepare to defend yourself here? And if not, why not?
Well, because I know what I know in my heart, and I know I am to be blamed for the signature. I know it.
That's not an
So-
answer. That's not an answer. Why did you not ask the people you delegated this to if they used artificial intelligence? And if not, why? You've told us you take responsibility. We're asking additional questions. Did you or did you not ask them anything?
As I stated, I knew they had used it. I know it from looking at it, after the fact. And I thought I could still have a time to clean it. The reason that I didn't want to ask them, because I already told them directly that they had destroyed me with whatever. And I told them the same thing, that there are classes how to use it, but the answer I received, we didn't have time. They said I didn't give them enough time. So we spoke with knowing exactly each other's mind, what transpired, and I instructed them going forward if they gonna be helping me out in that situation, because when I delegate, I am assuming it's done. I don't want to delegate and then I have to go through it again. But I know, I knew it. So
Counsel, did you delegate the preparation of the response in any way, or is that all your own work?
this response here,
Correct.
yes, I did it, Your Honor.
You did it by yourself.
Yeah, I did it.
Okay.
My response, I wrote it and then I send it to the clients for review.
Some of the problems that Justice Doherty pointed out with regard to the case not being good authority for some of the propositions in which you use them. You understand that? You understand the sort of glaring
I do, I do. But as I stated, every day we're still learning, new things from our mistakes. And I know this would have not happened. And I understand where you all coming from, because if I were in your shoes, I probably would see it the same way, but I didn't want to come with new cases since then. If I were to sit down today to file a brief from the scratch, I probably would do it differently. It's just my nature. When I start reading, I just can't get out of it for days, because reading this case, and yes, you can use artificial intelligence as long as you do exactly verify it. But since then, since I been, put in this situation, and I apologize for if the words sometimes don't come right, I'm translating in my fifth language in my head.
Counsel,
I know you can use it. I know you can use it, but in a certain way. For example, because English is not my first language, when I have something paraphrased, makes it look like better than picking quotes. And then I said to myself, I should not try to, put 2-3 paragraphs in one paraphrasing. Just use the quotes, even if it takes longer. Just use the quotes. So that's what I learned from it. Do not go to, because reading, like the paraphrases, like this court brought to my attention, saying, it says, a proposition of law and apparently do not appear to be in that case, because when I read it, when I paraphrase it, and then the paraphrasing is not helping me at all. I want to stick to just taking the quotes and putting the quotes directly. And the other issue is with this case, and the other attorneys that I asked to, and I sent them the draft to with the cases, the first response was, take this out, make this like this, their suggestion. So I went from 60 or 70 pages down to 40 pages. And then I had to reconstruct that. And then middle in it, the brand new computer that I had bought crashed too. So the recovery was version 1, version 2, something like that. Not saying it. So because of the time pressure, I just continued working on one version, but not the version that I had made the changes after the other attorney had suggested remove these from here, the facts go here, because in the remotely email, I did ask for help. And Lord knows, I begged them, as the time was counting for help. Again, it's my job. Why am I begging them? Because I didn't have time.
could you describe your practice to us? What other cases do you have pending? What other clients? I don't mean to name them. I mean, what kinds of matters are you handling in your solo practice?
So right now, let me start with, after COVID and after the earthquake, I moved to Texas.
We understood. We read your response. We know about
Okay.
that. I'm asking at right now, let's say from December to now, what has your practice been?
Okay. So I'm working out of my home, as I stated before. I have the cases that I have, and even during this time, I have one in the first district.
You have an appeal in the
Yes.
first district?
Yes. At the same time, simultaneously, I had case from here and case from there, and simultaneously, because that is now resolved around the same time as this appeal. So they were at the same time. And then that's also related to the state court divorce case in Cook County. I had other case in Skokie courthouse. In the federal court, I have another at the same time. I was working on motion to dismiss responses for that in the Northern District of
Tell me the
Illinois.
type of cases. What kinds of cases are you handling?
So the order protection that was appealed in the first district is that the Domestic Violence Act was misapplied in the court. So it is husband and wife, the domestic issue that went to the appeal, because the divorce court I had a plenary order of protection, and there was testimony and everything of inconsistency. So I had to read that transcript and file that appeal in the first district. And then I had to have a reply to that same, which was all around the same time. If this court wants, I can pull them out to you even in the contacts. And then in the federal court, I have one breach of oral contract between two citizens, one United States, one Turkey, and the guy got swindled. So the complaint that I filed, the opposing attorney filed motion to dismiss. And again, that motion to dismiss got repeated in the amended complaint, which right now I have taken extension to respond to it while all these appeals are pending. And then the worst case, the one that really drained most of my energy also is also in the Northern District of Illinois. It is fraud, not only fraud, it's a big case. It's against
Why are you taking
aircraft plane crash.
you're taking on a plane crash case in the federal court,
Yes,
and you're a solo practitioner?
and I can explain that.
Well, no, let me ask you a question. Is a language barrier present, and/or is your fluency in languages help get you certain clients?
Just that I am a Turkish speaking fluency doesn't matter. I was searched for Chicago lawyer to file the plane crash case. And when I initially took this case right after COVID, it was year 2021. At the time, I did have my staff, but I dissolved all the staff because we were working out of home. It was a difficult time. And then that case, I tried to give it to other attorneys. Nobody would take because they hired me as a Turkish speaking attorney. I was stuck with it. And you can imagine I am one attorney against 10 big litigation firm attorneys. And it just drained me out. And the only reason I couldn't, because I took it in 2010 in the Cook County, and then clients couldn't come for deposition stuff because they couldn't get their visas. At that time, there was a lot of unrest in around the Turkish area in Netherlands, and whatever the the American embassies were closed, the clients couldn't get the visas. So we had to voluntarily dismiss the case because they couldn't get visas. As soon as they got the visas, I refiled it in the federal court. But again, the only reason, because no other attorney would take it, and I took it, and I didn't want to have the statute of limitation issue. I didn't want to have the bad remark on my name that I took this case in 2021, voluntarily dismissed for lack of visas to come to the US, and now I'm refiling it. I tried to contact other law firms if they could please help me, if they could be co-counsel, if they could be fee splitting, who has more staff. I just don't have their staffs. And I always said, when I finish this case, I retire. I just.
When you
I am
finish
burned
which
out.
case? When you finish which
The
case?
Boeing case,
The Boeing case.
because it started in 2021. And I told my sisters, when this case is finished, I didn't think it was going to be that long. I would go see them. In 2021, I take the case, and then COVID, I can see my family. And then 2023, my family died, and this case didn't die yet. So I had to refile it because there is no other attorney that speaks Turkish, takes this case. And I took it. I have this loyalty issue when I'm in the case. Even if it kills me, I feel like I can't just bail out. And then having huge case against Boeing, And that other big case in federal case between this individual, they're both Turkish citizens, but one defrauded the other one, and they want to have a judgment so they can go after this guy in Turkey. So I was just born in Turkey. I am a mixture of mutts, whatever. I grew up in Germany all my life, but because my first name attracts Turkish, she's Turkish attorney in Chicago. When I did my first case in plane crash in 2013, 2014, I had 3-4 attorneys in the firm. But attorneys opposing sides don't play fair. They bring frivolous motions. They put document dump on you. They overburden you, and you have to answer them. That is the nature of this business, and it looks like whoever makes the best arguments and buries you in the paper wins. And I didn't want it to be that way, but I feel like.
Thank you. I understand the other litigation that you're involved in. Thank you for answering that.
You have any final comments for us, Ms. Lane? Anything you haven't already said?
First, I want to ask again if this court would be kind enough to allow me time to redo it, to show you, even with all these cases and solo practitioner, I'm looking for attorneys, but if you give me another chance to redo my brief, because the main thing, or the most important thing for me, I know you all have the power to punish me. And I just hope that you find in your heart that the greatness in when you can punish me, that you don't punish me, or that you don't punish me that severely. I know you want to make an example out of me, but I promise you, I am not a bad lawyer. I'm not, I can't even sleep and wake up without heart palpitation and panic attacks. How am I going to finish the deadlines? But if the ADA grants it, if you could grant me, you know, because it says the Title II of ADA, including 28 CFR section 35.130B71, it says the policy is access to people with disability, reasonable accommodation to allow amendment to ensure accurate participation. It wasn't 100% accurate, and I was hoping to have the time to, even the amendment that I had before I filed the amendment, I would have 100%, 110% gone through it. But in more than 20 years practice, I have not had an issue of this nature before. And this is isolated incident. It was, you know, breakdown of verification under pressure. I guarantee you this is not a pattern of conduct. And if you want to punish me, if you want to sanction me, I respectfully request that you do it in a nominal or proportionate that reflects the absence of bad faith and my prompt attempts to correct it, and my accountability, and I'm accepting all the responsibility to it. If you feel in your heart, I mean, for you, I'm just a number, but for me, I know the long-lasting effects of it. I assure you that this will never happen again. This was horrible experience. I want a chance. I want a chance to redo it. But I'm begging you, when I ask for extension, please, that is not to delay anything. I am struggling to finish up these cases so I can retire, so I can have a life without waking up with heart palpitations every morning.
All right, either of my colleagues have any further questions?
I do not.
No.
Right, I thank Ms. Lane for her time today, and I also thank her opposing counsel for their time in attending today. the court will now stand in recess, and if we have a decision to make, it'll be coming in writing.
Thank you.